All right, all right, all right. It looks like we are live. What is going on, Bree Hive? Welcome back to another lovely Thursday stream. And today we have a couple of things to go through, a couple of cases that are a little outrageous. We have an update on the Lizzo case. Her dancers responded to that motion to dismiss the case that we covered a couple of weeks ago. They're like, girl, you are not going to say First Amendment protection. And we did plead facts sufficient enough to withstand your motion to dismiss. We also got R. Kelly with a brand new freaking lawsuit, and he's suing the federal government and also our good friend Tasha K, who Cardi B also sued that we covered on this channel, a year or two ago. So we have R. Kelly suing the federal government for breach of his privacy while he was in jail. So we're going to get into that. It's going to be a freaking live reaction. So we'll see what's going on there. And then lastly, there was another elimination trial going on while we were covering Charlie Edelson and Donna Edelson and all the Edelsons. There was another elimination trial going on, and it was like a love triangle kind of situation, but not really. And that case actually just came to a conclusion today. So we're going to try to recap that case. Kimmy is working on a PowerPoint for us, so we're going to look at that. And then we'll do that at the end of the stream. So we'll start off with Lizzo. We'll go into R. Kelly and his nonsense, and then we'll end it off with the other elimination trial that just concluded today. And I think Austin, Texas, in Texas somewhere. San Antonio or Austin. I can't remember. But yes, that case just finished up. If you guys are watching live, go ahead and drop in the chat. Let us know that you are here live. Let us know where you're watching from. Let us know how your day is going or what you're going to do on the weekend. I'll jump into that. And for those of you that did not notice, we got quite a few new subscribers over the last day and a half or so from the Edelson cover and the Donna coverage. So if any of you that are new to the channel are watching, hello and welcome to the Bree Hive. Yes, welcome in. We're gonna have a good time. Let's see here. Okay, it's Austin, Texas. Thank you, Kimmy, for letting me know that in the backstage. All right, let's go ahead and jump into the chat, see who's watching live here, and then we're gonna jump right into the cases. We're not gonna warm up with Reddit today. If we have time at the end, then I will cover like a Reddit story or two. But right now, we're just going to start off with the cases, and then we'll go from there. We have Tanya D popping in early, a member and moderator of the channel saying, hey, Bree and Bree Hive. Hello and welcome into the live stream. Nice to have you here tonight. And saying a special shout out to everyone who hit the like button before the stream even started. We appreciate you. Yes, of course we do. We do appreciate you. All the likes, we hit 50 likes during the live stream on Tuesday. And somehow we got like 3.5K views on that video. And usually our live streams get like 200 views. So make sure if you haven't already, please do hit the like button. It does help us out in the algorithm. And I had a pretty good click-through rate on my thumbnail, so maybe my thumbnail was cool too. But yes, of course, if you haven't hit the like button, please do. And if you're not subscribed, please do subscribe. It helps us get more friends in the Bree Hive. And why would you want to miss the content? Summer Butterfly says, hello and good evening, everyone. Another member of the channel. Hello and welcome into the live stream. We got Queen Brielle saying hello, welcome into the live stream. That is a new name that I am seeing. Jazzy G says, hey, Bree in chat. Hello, welcome back to the live stream. Nice to see you. We got Jen saying, hey, from Oregon. Hello, welcome in. Bree Hive, Bree, me. I am in California, so welcome on in from Oregon. And we got Queen Brielle watching from Virginia. Hello and welcome in from Virginia. I'm seeing quite a few new names. So are these the new people that subscribed over the last couple of days? Let us know in the chat. Doozy0201 says in Georgia. Hello, welcome in. Our paralegal Kimmy is in Georgia too. Not to be giving out her location, but kinda. Nat Atat says, hey girl, Nevada County, California. Hello. That is pretty close, if I'm not mistaken, to where I am. I don't know. I'm not good with geography, but welcome into the live stream. Nice to see you. Kimmy Locker says, hello, Bree Hive. Hello. We got Kimmy in the backstage helping us out with a PowerPoint on the new elimination trial. or not new, it's over now, but it's new to the channel. And we're going to go ahead and jump into Lizzo. So for those of you who have not been keeping up with the Lizzo lawsuit, Lizzo has 2 lawsuits. If you don't know who Lizzo is, she's a singer, dancer, performer, celebrity lady, right? And she promotes, body positivity and all of the things. Her dancers sued her first. 3 of her dancers sued her first. And then we had the costume designer suing her next. Then Lizzo went ahead and responded to the dancer saying, no, she doesn't agree with anything. And then she turned around and filed a motion to dismiss for failure to state a claim, because she basically said that they were a part of it. They participated in everything. So now they cannot try to claim all of this harassment and the sexual harassment, disability harassment, all of these things. She didn't even know about the disability. So how the heck are you going to file a lawsuit against me for those things? So she sent that into the court. What was that, about last week or 2 weeks ago? We covered it. And then now the dancers are filing their response saying, oh, no, we have stated our claim. And your position regarding First Amendment protection is absolutely wrong. It's absolutely wrong. Are they right? Probably. They are probably right. But let's go ahead and go through it. Let's see what they had to say. And like I said, welcome to the new people that came to our channel over the last day or two. And let's go ahead and jump right into it. We are not going to read everything on this. Like I said, it's a live reaction. So, if I'm messing up, that it is what it is. So welcome to Lizzo. Let's make this a little bit bigger, but my face even bigger than the words. Okay, so this is the plaintiff's memorandum of points and authorities in opposition to Lizzo's motion or special motions to strike. Okay, so let's see. It's the dancers against Lizzo, her company, and some other people. They are submitting this points and authorities to challenge what Lizzo said in her document. So let's scroll into the meat and potatoes. Let's get into the introduction. Can a global celebrity be forever insulated from civil liability because all their conduct is protected as free speech under the Anti Slapp statute? Probably not. Defendant Lizzo asked this court to rule in exactly that fashion. Fortunately for all victims of celebrity malfeasance, the law says otherwise. So they're basically saying Lizzo is completely wrong with her position and saying, oh, anti-Slapp, I'm protected by free speech by, I don't even remember what she said she was protected under free speech under. Like, which allegation was she protected under? I don't remember. Okay. We're not going to go through the factual procedure. Let's go into the legal argument. The moving party seeks to strike the complaint because it's based on any other conduct in furtherance of the exercise of the constitutional right of free speech in connection with a public issue or an issue of public interest as protected by this Code of Civil Procedure. Oh yeah, I forgot. She said that it was the whole, all of the allegations were protected by free speech, which of course wouldn't apply because of some of the stuff was actual like assault and false imprisonment and things like that. So that would not be protected by free speech. You're not talking when you're locking someone in a room. You might be talking, but the actual act of locking someone in the room, you're not going to be protected by anti-Slapp. Okay, a court evaluates an anti-Slapp motion in 2 steps. Initially, the moving defendant bears the burden of establishing that the challenged allegation or claims arise from protected activity in which the defendant has engaged. If the defendant carries its burden, the plaintiff must then demonstrate its claims have at least minimal merit. So it doesn't have to be exact, it just has to be minimal merit. Let's see, they didn't go through the second one. All right, let's go into it. Defendant's conduct giving rise to plaintiff's claim is not protected under the anti-Slapp rule. This first step of the anti-Slapp analysis turns on 2 subsidiary questions. What conduct does the challenge cause of action arise from? And is that conduct protected activity under anti-Slapp statute? And this is like a little lesson for me too, because I always see anti-Slapp, free speech, all of the blah, blah, blah. But it's kind of confusing how it works. So let's jump into it. Let's learn about it together. Defendant does not cite facts within any claim from which it arises. A claim does not arise from protected activity merely because it was filed after or because of protected activity or when protected activity merely provides evidentiary support or context for the claim. If the plaintiff can establish the element of the plaintiff's claim without relying on protected activity, then the claim does not arise from protected activity. The court must distinguish between speech or petitioning activity that is merely evidence related to liability and liability that is based on speech or petitioning activity. Let's see if they let us know what it is. Plaintiff's allegation that defendants retaliated by pursuing these investigations of plaintiff arose from unprotected conduct. This speech is not by itself the basis of the retaliation claim. Defendants do not want this court to exercise this distinction. In an apparent effort to dupe the court, defendant, so Lizzo, either cherry picks allegations or outright omits allegations inconvenient to their position, instead sanitizing them with euphemisms. For example, in the assault claim where it is specially pled, Lizzo cursed at, then approached plaintiff with balled fists, where plaintiff believed Lizzo was going to strike her. Defendants cite as statement and conduct by Lizzo at the dance cast meeting. This disregards for what is pled should be grounds to deny the present motion. Regardless, plaintiffs here cite the facts pled for each claim. The first claim for sexual harassment specifically alleges and arises from being forced into a nude photo shoot, watching defendant Quigley practice oral sex with bananas, Quigley talking about masturbating, and defendant Lizzo exposing plaintiffs to graphic sexual acts and sex bar and forcing one plaintiff to touch a sex worker. The second claim for failure to prevent remedy sexual harassment specifically alleges and arises from the aforementioned conduct. So not speech. You're not protecting speech here. The third claim for religious harassment specifically alleges and arises from Quigley's repeated imposing and exposing her beliefs on plaintiffs. The fourth claim, failure to prevent a remedy for religious harassment, specifically alleges and arising for the aforementioned conduct. So again, not speech. The fifth claim for racial harassment specifically alleges and arises from management desperate treatment of Black dancers. I don't think this one is a good one. They basically just said that only the Black dancers were referred to as lazy, but if you are not a white dancer or Hispanic dancer, how would you know they were not called lazy, because they weren't saying, they kept saying it out loud only to them. It was more, if I remember correctly, in more private settings versus actual settings where everyone was there. So I could be wrong, but that's how I remember it. The sixth claim for disability discrimination specifically alleges and arises from defendants threatening to fire plaintiff after learning of her mental disability. I don't think that was going to fly because she literally was like, oh, I have anxiety. And so I recorded a conversation I knew I was not supposed to record. And then because I would black out or my vision would go blurry and then I couldn't hear anything. So I don't know how far that one is going to go, but I think that is one of the allegations that should be dropped. The seventh claim for intentional interference with prospective economic advantage specifically alleges and arises from defendants putting a soft hold on plaintiff's ability without compensation and preventing plaintiffs from getting or even learning about other economic opportunities. The eighth claim for assault specifically alleges and arises from Lizzo's cracking her knuckles, balling her fists, yelling, you're so effing lucky, with plaintiff believing Lizzo would have struck her had it not been for the intervention of others. The ninth claim for false imprisonment specifically alleges and arises from Davis instructed to not leave the room unless she submitted her phone to defendant security and gave access to same defendants. So they just went through all of the claims that they're making. And a lot of them, some of them do have speech included in it, and then other ones don't. So I see where they're going with that. Okay, let's see. Number 2, defendants acts given rise to the complaint fell Film On's analysis for subdivision protection. The Supreme Court of Film On Inc. versus Double Verify provides specific analysis on whether conduct falls within the ambit of other conduct encompassed by the subdivision. Okay, so it's going to tell us what the conduct part of it is. Let's see here. They set forth a two-part analysis. First, we ask what public issue or issue of public interest the speech in question implicates. A question we answer by looking to the content of the speech, which I don't think she's going to be able to succeed on this because it's like private incidences where she's like threatening them. So it's not a public issue of her dancer sucking or being, not cooperating with her, whatever you might want to call it. Second, we ask what functional relationship exists between the speech and the public conversation about some other matter or about some matter of public interest. Film On involved a media provider, FilmOn.com, sued an authentication service, Double Verify, for defamation for characterizing Film On's content as adult content, much like some of the claims in this actual complaint against Lizzo, or copyright infringement and confidential reports provided as a paid service, but it's a private service. Let's see. Double Verify filed an anti-Slapp motion. The Supreme Court ruled the reports were not protected. Why not? Give us more information. Defendant's conduct in the complaint does not implicate public interest issues or interest. The Film On court first noted that virtually always defendants succeeding in drawing a line, however tenuous, connecting their speech to the abstract issue of public interest. But the inquiry is whether a statement contributes to the public debate is one a court can hardly undertake without incorporating considerations of context, including audience, speaker, and purpose. Film On noted that although children's exposure to sexually explicit content qualifies as an issue of public interest, the focus of the inquiry now must be on the specific nature of the speech rather than the generalities that might be abstracted from. And this is why I don't understand anti-Slapp, because it's like public interest, but private things that you have to pay for could be considered public interest. I guess because there may or may not have been an audience when Lizzo did what she did. Let's go on. Let's see. I'm confused. Let me know if y'all are keeping up in the chat because I'm a bit confused. None of plaintiff's claim arise from conduct implicating a public issue or interest. How exactly does Quigley relaying how she masturbates? How does Quigley relaying how she, satisfies herself or performs oral XTX on bananas implicate public interest? It's a sex ed class. What do you mean? In the middle of dance class, I get their position there. Let's go on. Or when Lizzo attempted to strike plaintiff Rodriguez, or when plaintiff Davis was deprived of her phone and confined to a room. These, they put these. It wasn't me messing up that time. These acts, which give rise to the claims at issue here, do not implicate public issues and thus cannot be protected. I agree with them there. I would love to see what Lizzo argues with that one. Defendants, with a broad stroke, argue a list of categories of conduct such as cast personnel management, negotiating terms of employment, critique of performance, termination, personal meeting, cast meeting, prayer circles, and cast outings were either fundamental to preserving the creative integrity or were integral in the iterative creative process in creating the TV show and tour where the plaintiffs contend they suffered violations in rights. So she's basically trying to group them into all of these categories, which appear to be protected. I don't see how. Anti-Slapp confuses me, y'all. I'm not even going to lie to you. Anti-Slapp confuses me, so let me just read it and then we can talk about it in the chat. Presumably, moving parties assert conduct related to the creative process is conduct implicating public issues/interest. However, as explained below, not all conduct within the creative artistic framework is in furtherance of free speech connected to a matter of public interest. So I think I get where they're trying to go with that, since art, freedom of speech, talking, doing art, sciences are a form of public interest. People like art. People you have to have this creativity. And so basically they're saying within their group of learning how to dance, whatever Quigley wants to do in front of them is basically protected because there's a public interest of artistic creativity. I would have to agree with these defendants that that's not how that works. I'm not an anti-Slapp lawyer or anything of that nature, but I'm pretty sure they're on the right track with that. However, I do still think that a lot of their positions fail in general, not just because of anti-Slapp, but because it's a non-issue that they're trying to make into an issue. So let's see here. Functional relationship between conduct and the complaint and public interest. Film On's second part of the test moves from a focus of identifying the relevant matters of public interest to addressing the specific nature of defendant speech and its relationship to matters of public interest. The question is answered only by looking at the broader context in which the speech was made, discerning through the context whether conduct qualifies for statutory protection by furthering the public conversation on an issue of public interest. Masturbating probably doesn't fall into that. Deep throating a banana also probably doesn't fall into that, Lizzo. I'm sorry. Film On found Double Verify's reports, although implicated the public interest in preventing children from seeing adult content did not further the public conversation because those reports were provided privately to paying clients. Okay, so I guess I misunderstood it earlier. So the private reports were not of public interest because they were private. You had to pay to get them. Okay, that's how I think it should work. The Supreme Court found that Double Verify did not issue its report in furtherance of free speech in connection with an issue of public interest. Okay, I misunderstood it the first time I read it. I am understanding it correctly. 2 months after Film On, the California Supreme Court revisited a subdivision E4 analysis in Wilson versus Cable News Network. There, a writer-producer for CNN sued CNN alleging discrimination, retaliation, and defamation. Remember, this is pretty close to what these plaintiffs are claiming. And he was denied promotions, given less favorable assignments, and ultimately fired because of his race and other protected characteristics, as well as in retaliation for complaints and taking parental leave. CNN filed an anti-Slapp motion arguing that alleged conduct was protected as matters of public interest, i.e. the creation. Where did it go? The creation of a news broadcast. So you was like, okay, so you're Black and your creativity doesn't work for us anymore. Is that what your argument is? I don't know the facts of the case, but I'm just making. How did they come up with that? Okay. Wilson acknowledged the public interest in the new CNN broadcast, but noted not every staffing decision. Yes, the fact that you are a certain race does not have to do with being able to have your creativity and creating the type of, well, I guess if you're CNN or Fox News, maybe your race does matter or your political position does matter. So maybe this, I see where they're going with it, but is it correct as far as this goes? Probably not. But noted every staffing decision a news organization makes, even with respect to those who write, edit, and otherwise produce content, enjoys a constitutional protection. Wilson found the allegations of denial of promotion or assignment of less favorable tasks did not have substantial relationship to CNN's ability to speak of matters of public concern. Well, if he's behind the teleprompter and he's just putting whatever he wants on there, then that could definitely be an issue. As for defamation claim, Wilson cited Film On's ruling and defendant who claims his speech was protected. Must show not only that the speech referred to an issue of public interest, but also that its speech contributed to public discussion or resolution of the issue. While acknowledging the story the employee worked on was a matter of public interest, the claims are found not to be based on the story, but rather rested on the statements that led to the employee's termination. Wilson noted not every employment dispute is a matter of public significance. Workplace misconduct below some threshold level of significance is not an issue of public interest, even though it implicates public policy. I thought this was shorter. Defendant's conduct in the complaint does not contribute, nor is it in furtherance of free speech. The central question is whether defendant's conduct giving rise to plaintiff's claim not only touches on a matter of public interest, but also that they contributed to public discussion or resolution of an issue. Yeah, the whole banana thing, I don't think they got it for us. Williams' circumstances are analogous here. Although plaintiff's allegation giving rise to their claims deal with a topic of public interest, because of Lizzo's fame, the conduct defendants are alleged to have committed giving rise to the claims are not in furtherance of free speech and thus are not protected. Here, defendants failed to discuss the film on analysis. This opposing party can only look to the act specifically identified in the discussed labeled in furtherance of the exercise of free speech, personnel management, personnel meeting, dance cast meeting, pre-show prayer circles, and cast outings. Defendants conclude these activities were integral in the iterative creative process involved in the creation of Watch Out for the Big Girls and the production of the tour. However, other than identifying these broad categories of conduct as part of the creative process, defendant makes no effort to analyze how any specific allegation, i.e., or for example, unsolicited insistent imposition of Christian faith, disgusting masturbation, performing acts of oral sex on a banana during breaks, pressuring or touching a nude sex worker in Amsterdam, being coerced to stay in a room and handing over a phone, Lizzo balling her fists while yelling at plaintiff in fury, requiring physical intervention, and desperate treatment of Black employees by management. I think they characterized it a little broad, themselves, but I'm done. Contributed to and was in furtherance of the public discussion of a matter of public interest. Instead, defendants dwell on erroneous premise that by merely being in the creative and artistic field, their conduct is that de facto protected under subdivision E4. It is not that simple. Where are we at? I thought this was only like 3 pages. Okay, we're almost done. Where was I at? It's not that simple. Defendants rely too heavily on the creative process cases distinguished here, as those activities have been meaningful nexus on the artist's creative output for the TV show or music. Let's see. In this other case, a couple's lawsuit against CBS was subject to slap because defamation claims derived from defendants' use of their real names in a CSI script and writing script that led to a broadcast of a TV show was an act in furtherance of free speech. And Daniel versus Wayans, a suit alleging racial harassment during the production of a movie while the camera was off, was subject to slap because the alleged conduct was not incidental to free speech, but based solely on defendants' exercise in the protected production process. And Hunter versus CBS Broad Inc. suit alleging age and gender played a role in plaintiff's non-election of a weather anchor was subject to slap because selection of who reports the news is protected speech. Let's see. And Simmons versus Mahoney, a drummer's FEHA suit alleging termination due to age and disability was subject to slap because selecting who performs with the artist is in furtherance of free speech connected to a matter of public interest. Unlike the present dispute, this person has so many typos in there. In the present disputes, I've been skipping over some of them, but there's a lot of typos in here. These cases, defendants cite involve a direct functional relationship between the alleged conduct and plaintiff's creative/artistic output. Choosing a drummer to perform, conduct during movie production contents of a TV script. But here, there is no functional relationship between the acts that give rise to the plaintiff's claims. They repeat everything again, and defendants writing/making music or putting on concerts. Lizzo's celebrity status alone is insufficient for protection under this subdivision. Defendants argue Lizzo's level of celebrity has transformed her, the most mundane aspect of her life, into issues of public interest. However, a defendant's celebrity status on its own is not sufficient to render anything that defendant says or does subject to anti-slap protection. I would agree with them there. No authority supports the defendant's broad proposition that anything said or written about a public figure in a public forum involves a public issue. I would agree with them there. Bernstein versus LaBeouf involved a bartender suing Shia LaBeouf. LaBeouf filed an anti-slap motion arguing the public's fascination with him. Way to be cocky, Shia LaBeouf. The public's fascination with him and the widespread interest of his personal life render his day-to-day conduct a public issue or an issue of public interest. The Bernstein court discussed Film On's analysis and noted the social or celebrity status of a party does not, without more, convert anything that a party says into a matter of public interest. That line goes directly to what the defendants are asserting. Rather, the focus of the public interest inquiry must be on the specific nature of the speech, rather than on any generalities that might be abstracted from it, such as the fact that the defendant regularly injects himself into the public spotlight. Bernstein held LaBeouf's conduct was not protected. Under Film On and Bernstein, Lizzo's celebrity status does not, without more, render her activities into protected under subdivision E4. As noted above, the only activities beyond celebrity status the moving parties direct us to our generalized categories of conduct without citing the individual claims of actual allegations. There is no discussion how these categories of conduct combined with Lizzo's celebrity contributed to public discussion of a matter of public interest. Indeed, it is a hard argument for the moving parties to make. Cast meetings are for the cast members only, not for the public to observe. Prayers before the shows are also for the participation of performers only. Finally, cast outings with Lizzo, although in public, are by their nature to be for the crew members invited to participate in these outings. But these categories are not what is actually pled as to what gives rise to each claim, as discussed above. For these reasons, plaintiffs asserts and pleads that conduct that give rise to their claims against defendants are not protected under the anti-slap. Sorry. And then they go into how they submitted evidence that was sufficient to state a claim. We can briefly go through that, but I will check out the chat really quick to see what the peoples are saying. Y'all, my nose is stuffy right now. I think it's because I ate candy. And so it's making it hard for me to breathe. So please excuse me for continuously clearing my throat. Let me go ahead and see what the chat has said while I was gone. Hello, Hella Swanky, member and moderator of the channel, saying hello, Bree Hive. Hope everyone is well. Hello, welcome back into the live stream. I hope you are doing well as well. Jen says, Bree, when you have a moment, can you explain what anti-slap is? Sorry. Yes. When to the best of my ability, I will explain it because I know the context of it, but not super familiar with it. So let me actually bring up a definition. It's basically something that celebrities can assert. It's mostly celebrities that assert it. It's basically freedom of speech. So the celebrity or the person making the statement should not be limited in their statement because they are protected by their First Amendment right to talk about things that are of public interest. So, what do you call it? Lizzo is asserting that since she is a performer and an artist, her deciding to kick the girl out of the room is protected by free speech because the girl was, or free speech or artistic creativity, because the girl was recording actual conversations that were going on in a private meeting between the dancers. And that was actually a part of their contract that they weren't supposed to let that out. So let me actually just look up the anti-slap definition so that we can look at the definition. It confuses the heck out of me. So here we are. Okay, it stands for strategic lawsuit against public participation. Let's go ahead and click on it. And then it says, contrary to the name, an anti-slap motion is not a motion that has anything to do with slapping anyone. SLAP is an acronym for Strategic Lawsuit Against Public Participation. An anti-slap motion is a motion to strike a lawsuit, so you could dismiss the lawsuit because it's talking about public interest, brought primarily to chill the valid exercise of constitutional rights of freedom of speech and petition for the redress of grievances. Where to use it? The special motion to strike applies to any cause of action arising from an act in furtherance of a person's free speech or petition rights, or both under either the United States California Constitution, or under the United States or California Constitution. The general idea behind the anti-slap statute is that you have the right not to be sued because you exercise your constitutional right to say what you think or enforce rights by filing a lawsuit. So basically, if someone tried to sue the Beehive because of what I say on the internet, I could potentially use anti-slap. So let's say Charlie Edelson is mad at me because I said that his mom and his sister needs to be arrested. That's an opinion, so you probably can't do much about that. But either way it goes, I would probably be protected by anti-slap. If I remember correctly, someone sued Natalie Lawyer Chick, and I think she won using anti-slap, because what we're talking about on this channel is of public interest. What are the celebrities doing? What are they being sued for? Can we explain it? I'm talking about anti-slap. I'm not that familiar with it, so we're looking up the definition online. So basically, since art is a protected class under the First Amendment, let's pull up the First Amendment because I don't remember it off the top of my head. So First Amendment. Okay, First Amendment to the Constitution. Where are you? Okay, so the First Amendment, Congress shall make no law respecting an established religion or prohibiting the free exercise thereof, or abridging freedom of speech or of the press, or the right of people peacefully to assemble and to petition the government for redress or grievances. So freedom of speech, like I said, it includes artistic things, freedom of press, us getting on the internet and saying what we think online. This is a form of press, although we are not CNN. We are giving our press on the lawsuits that we cover here. And in Lizzo's situation, she's saying, okay, I'm a dancer, I'm putting on shows so I can, talk to my dancers about what I need to talk to them about, and they shouldn't be able to sue me for those things. Or if I put this particular dancer in this outfit because of creativity reasons, they should not be able to sue me because of that. So I hope that makes sense. I don't know. Anti-slap is hard, but I know it's the protection of your First Amendment right, and she's asserting it under the artistic creativity provision of it. Let's see. Kimmy Locker says to Jen, SLAP is short for Strategic Lawsuits Against Public Participation. Thank you for that, Kimmy. Jen says, thank you. Thank you, Kimmy. So basically protecting public figures from frivolous lawsuits. And apparently it doesn't have to necessarily be famous people. It can be me here. I'm not famous, right? So it doesn't necessarily have to be famous people or public figures. It can really be anybody from what I'm gathering, but I'm not a anti-slap lawyer. But I'm pretty sure it can be anybody as long as you're, furthering the public interest. Like the sky was falling, and I got on the internet and said the sky was falling and it's Kimmy's fault because I saw Kimmy pulling the sky down. I could probably get away with that. I could probably get away with that. Kimmy Locker says to Jen, I wouldn't say it's meant to protect public figures as much as protect anybody who's publicly critical of someone or something, so the courts can't be misused as a weapon. Yes, exactly. Jazzy G says, has Lizzo responded to the other lawsuit? I don't think so. If I remember correctly, she hasn't responded yet, but that one also is a little later. I think it's like 3 months older than the original one. Jazzy G says the shade. It is the shade. It is the shade. Okay, let me go back into the live stream. Yeah, you guys know how I do. Just accuse Kimmy of, making the sky fall. Because I saw her doing it. So I could talk about it. It's of public interest. We don't want the sky to fall. Jen says, I'm also not sure news broadcasts should be creative. Right. I think it's because one is press. It's considered press. They're putting on, as much as we don't want to consider it a show, it's a show. They're giving us information, and right into the First Amendment, it's freedom of speech or the press. So the news channel is considered the press, so maybe not so much creative aspect of it, but the informative aspect of it. Or if you're not of someone's same what do you call it, political background, you might screw the freaking teleprompter up. You never know, right? So hopefully they're not saying this is creative works on the news, but it does fall into that category. Kimmy Locker says, you want to see cocky? Wait till we get to R. Kelly. Oh yeah, I skimmed R. Kelly because I was like, what the heck is he talking about? Hello Swiggy says, have you hit the like button tonight, Bree Hivers? Yes, of course. Thank you for the reminder. If you haven't already, please do hit the like button. It helps us out in the algorithm. We are actually doing really good, guys. We are at 23 likes with 22 people watching live. But if you have not hit the like button yet, please do. It helps us out in the algorithm, helps us gain new friends. And as you guys can see, we have some new friends. Kimmy Locker says, wait, what sky did I pull down? Hey, don't sue me. It was an example. It was just an example. Okay, so let's go ahead and jump into the lawsuit. They basically say that they pled facts sufficient enough for all of their claims. So just as a reminder for us, just in case they did not remind us enough about the banana and the masturbation, we're going to go through it all again. So what did they allege? They alleged hostile work environment. This included being quote unquote forced to go out to the banana bar where she was forced to touch a quote unquote sex worker, a dancer. Don't know if that makes you a sex worker, but whatever. That's what they put in there. They also were subjected to the Quigley, I think the dance instructor or the lead dancer, whatever she was, to, in their words, deep throating a banana and talking about her masturbation antics. And then they also had a failure to prevent hostile sexual harassment, basically saying that they tried to tell Lizzo or management that this was going on and no one did anything to stop it, and that they didn't know who to tell after they were basically rejected the first time. The next thing is religious harassment. They basically said that Quigley, who is again the dance instructor, something with the dance team, basically talking about her belief in God all the time, doing prayer circles, asking about some girl's virginity because she should keep the virginity because, religious reasons. They also talk about failure to prevent that situation, saying that they told someone and no one stopped it as they were supposed to under the law. And then we have the racial harassment. They claim that only Black girls are called lazy. I find that hard to believe. And also, if you are a Black girl and you're constantly hearing that you're lazy, and they're saying it to the white people or the Hispanic people or the Asian people too, how would you know? Because you are not that same race. So when is this happening? I think we need more information of when this is happening, right? So there's that one, the racial harassment. And then there's the disability discrimination. This is where she claimed that she had anxiety and depression, and Lizzo knew about it. However, she started recording private instruction of I think it was like critiques of their dances. And she recorded it and she claimed because she had blanked out one other time to the point where she couldn't listen and she went blind. I don't think Lizzo or the team knew about that, so I don't think that claim is going to go for it. Intentional interference with the perspective of economic advantage. This is basically Lizzo saying that you can't dance for anyone else or work on any other shows as long as the tour is pending. And also, we're not going to pay you while you guys are on break. So there will be like 2-week breaks where they're not actually performing. And Lizzo basically said that they cannot go and perform with anyone else. They did ask for money, and eventually Lizzo did start paying them money on the breaks, but that was one of the issues that could potentially still go forward. Could that fall into Anti Slapp? Maybe. I don't know. I don't know. And then there was the assault. They basically said, what was this one? Oh, that Lizzo came to her with her fist balled up saying, "You're so effing lucky," as if she was about to hit her, Rodriguez, and they're claiming assault for that. And then false imprisonment, where Lizzo told Homegirl Davis that, look, they messed up a typo again. Like, I'm not even reading it and I see the typos. And then so she told her, "You have to give me your phone," because remember, she recorded the freaking conversation with the critiques to the dancers and whatever other critiques they were having. She recorded it. It's in their contract not to record these meetings, and Lizzo was trying to get the phone back, but probably did not do it in the best way. Basically locked her in a room and said she couldn't leave until she gave the phone. That would probably be considered false imprisonment. So although we don't like their allegations, or at least I don't like their allegations and their claims, I think some of them will be able to move forward. Now, do they want this to go forward in trial and all of their dirty business be put out on the stand? Maybe not. Maybe not. Maybe we don't want to know that they participated in Banana Bar and they was the ones doing the do. Okay. Maybe they were the ones, cussing Lizzo back out. They were all in an argument about to get in a fight. Who knows, right? So I'm thinking that they're hoping that this settles and it doesn't go to trial. But I think Lizzo will probably take it all the way just to get that information out there in the public. Let me know what y'all think about it. I'm going to go ahead and check out the next chat, and then we are going to jump into R. Kelly and his nonsense. I just realized I left my light on. My stream is not set up how it's supposed to be set up right now. All right. All right, so let's see. Mary Jane says, "I'm late. I was watching Kurt." Well, welcome into the live stream. Nice to see you, member of the channel. Saying hi, Bree. Love you. Hello, love you too. We are happy to have you back here. And it's really not Sarah, but I always say Mary Jane because that's the name I see first. So Hello Swanky says, "Nah, no such thing as long as you made it. Good to see you." To Mary Jane, yes, of course. Welcome on into the live stream. We were just talking about Lizzo and the response that was given to her motion to basically dismiss the claims of the discrimination, of the harassment, of the assault, all of the things. I think that the defendants have a pretty good argument, to tell you the truth. I really do think they have a good argument. Mary Jane says, "Is Lizzo canceled? LOL. I'm not into her after Banana Gate. I liked her song." I don't think she's canceled. I really don't think she's canceled. She's just been kind of quiet for me. I like the cases though. I think some of the claims are stupid, but there are some that could succeed. Tanya D says, "I can't take these people seriously with all the typos. Very unprofessional." I would give them the argument that they probably did it really quickly, and it is a lot of pages. I have typos sometimes, but this many typos, I think not. That's a lot. And with these big firms, they should have multiple people reviewing it, and so it should be a lot better. So I kind of agree with you, Tanya D, but kind of like, oh no, I've done it before. Hello Swanky says, "I think Lizzo must have pissed off the wrong industry exec who is now on a mission to bring her down. La Janet's 2004 blacklisting. That, or she is just one of the worst people in the industry." I think it's just the dancers, and I think it was explained in Lizzo's motion to dismiss, and in her response. She basically threw the kitchen sink at the wall and hoped something stick. But she was like, no, these people were engaging in it. They're basically just mad that they got fired. I think a lot of that is truth. But some of this stuff is probably going to go forward, if not all of it. Hello Swanky says, "Weeks, months later, all this new info and lawsuit is still just a goofy to me as when I first heard about it." And it's just going to keep going on until it's over. On until it's over. And on until it's over, let's get into the next one. Yay, we are here to the next one. We are talking about R. Kelly. R. Kelly is back from can we call it the dead, the grave? I don't know. R. Kelly is back. And this time, he is not the one on trial. He's not the one being sued. He's not the one being prosecuted. My boy is suing the federal government and Tasha K. R. Kelly, you are suing the government and our fellow YouTuber, Tasha K. Oh. Yeah. Crickets for him. Because I don't know where he's going with this. I skimmed it. It's a little crazy. I did not realize he was suing Tasha K. For those of you who do not know who Tasha K is, she is a fellow YouTuber, but she does like gossip talk, not legal talk. And she was actually sued by Cardi B for defamation, and Cardi B won. Cardi B won, and now Cardi B is trying to collect her $4 million. Tasha K said she ain't got it. And so R. Kelly said, you know what I'm going to do? I'm going to sue you too. I'm gonna sue you too, Tasha K, because you need to stop talking. And he said she got 1.3 million followers. So I guess her YouTube channel went back up, because after the Cardi B thing, she had went under to like 900,000 followers. But in his report, or in his document, his filing, he's saying she has 1.3 again. I have not gone to look at her channel again to confirm or to confirm or deny. Is it deny? Confirm or deny to figure out if it's true or not, okay? I'm messing up on all my little colloquials right now. So let's go ahead and jump into it. R. Kelly, you are doing prison time for assaulting minors. And this is what you're doing in your free time. Don't tell me you're in that law library finding things, finding things that you think you can sue people for. Okay, so we have a Robert S. Kelly, that's R. Kelly, singer, musician. Is he an actor? I don't know. He's accused of doing a lot of weird things, and he was convicted of doing a lot of weird things. The United States of America is who he's suing. You gonna sue the whole country? Okay. Unknown BOP Officer A, unknown John and Jane Doe BOP officers, and Latasha Kiwi, also known as Tasha K. This is a complaint. Plaintiff Robert S. Kelly, by his undersigned attorney, for his complaint against the United States, known against unknown BOP Officer A, unknown John and Jane Doe BOP officers, and Latasha Kiwi. Introduction. Let's see what he has to say. Plaintiff sues the United States. That's just killing me. The United States of America. R. Kelly is suing the United States of America. Unknown BOP officer, also unknown, or also known as Officer A, unknown John and Jane Doe BOP officers, and Latasha Kiwi for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the federal tort claims. Plaintiff also brings suit against defendants BOP Officer A for violation of Computer Fraud and Abuse Act. Where did he get all of the information from? Plaintiff is a high-profile prisoner. Yes, he is a high-profile prisoner. He don't got no money, though, allegedly. But high-profile prisoner of the Bureau of Prisons. He is a Grammy Award, not gloating of your accomplishments, but let's go on. He is a Grammy Award-winning recording artist and a nationally recognized celebrity. As with all prisoners, but particularly because of plaintiff's status, the United States of America, through the BOP, had a duty to protect plaintiff and his private and sensitive information to ensure that its employees did not exploit plaintiff for financial gain or for any other reason. The defendant, United States of America, breached this duty of care. I don't know if you can get the USA, man. I really don't know. But again, this is not even my area of law. So I'm just going to read it for the vibes at this point. But I can't stop judging. I can't stop judging. So let's see. The defendant, United States of America, breaches duty of care to plaintiff when it allowed countless BOP officers to access plaintiff's confidential information without any legal basis to do so. The defendants, United States of America, knew that defendant BOP Officer A and other defendant John and Jane Doe BOP officers routinely access plaintiff's private information from its systems and divulge private information to third parties for monetary gain, clout, and simple harassment. How do you know? How do people find this stuff out? Okay. Because of the United States of America breach, at least 60 BOP officers made unauthorized access to plaintiff sensitive, confidential, and private information maintained by the BOP and its electronic system known as TrueView. Some of those BOP officers either shared and or sold that information to third parties, including members of the media and witnesses in plaintiff's criminal prosecution. Well, that might be a good thing they got that information. Defendant's unknown BOP officer A accessed plaintiff's private BOP records, including email communication, visiting lists, inmate trust accounts, and recorded phone calls with third parties and plaintiff's attorney without authority to do so. You know those phone calls are recorded. Are the officers supposed to be accessing it? Probably not. But, the prosecution can use it against you. The information was private and concerned personal matters. It was not public information. After unlawful accessing the foregoing protected information, defendant BOP officer A unlawfully downloaded the information. That's wild. Downloaded the information and sold said information to defendant Kibi. Tasha K, this your source? Is this your source, Tasha K? R. Kelly said you got sources in the prison system. Okay, gave it to Tasha K, a popular YouTube blogger with over 1 million subscribers who published the private information publicly without identifying how she received it. Now I got to see what she went and published. What did she publish? Defendant Kibi rallied her massive following to harass the plaintiff with the use of the stolen information and created chaos in plaintiff's personal life, even using the information to influence witnesses in plaintiff's Eastern District, New York criminal prosecution. On information and belief, the stolen information was shared with and used by prosecutors from the United States Attorney's Officer as a tool to influence witnesses against plaintiff. The sale of the information yielded profits that neither defendant BOP Officer A nor defendant Kibi were entitled to, and which belonged to plaintiff, if anyone. We know you don't have no money, R. Kelly, so I know you're trying to get some money, but, I don't know if you would have made money off of that information if allegedly they did it. The Department of Justice of the Inspector General investigation initiated a secret investigation into the unauthorized access of plaintiff sensitive information. The department did not inform plaintiff of the investigation and never has. Plaintiff later learned the investigation resulted in the issuance of a search warrant for a BOP computer used by defendant BOP Officer A and a forensic analysis of the computer. Oh, so the United States did their own investigation. And that's how he found out. So, okay, USA, you might be on the hook for not telling him about it. I don't know. That's not my area of law, but let's go on. According to an affidavit of Special Agent Matt Lukes of the Department of Justice, later obtained by plaintiff's attorney, probable cause existed to believe that defendant BOP officer committed a criminal violation of the USC statute, that is, unauthorized access of a computer to obtain information from the Federal Bureau of Prisons. No charges were brought against defendant Officer A, and the government has refused to reveal any details about the investigation, including the identity of Officer A. In short, there has been a cover-up of the rampant BOP misconduct that is going on. It has been a cover-up. Oh my gosh, R. Kelly. I see the problem, but it's very, very hard for me to feel bad for you. It's just hard for me to feel bad for you. Let me see what the chat is saying, and then we'll go back into it. Let's see. Mary Jane says, "Oh, Bree, you can just say Mary Jane or MJ. I don't care." Okay, got it. Because I was like, oh, it says Sarah. Jersey G says, "R. Kelly and Tasha K never thought I would hear them in the same sentence, right? I didn't even know she was talking about this man. Now she getting secret information from the prisons." Tanya D says, "I didn't do it, Robert Kelly. Leave me out of this." Wait, no one said you, Tanya. Not Tanya D, Tasha K. Mary Jane says, "Ugh, I hate R. Kelly. Ever since the scandal, he's a creep. He's been a creep. He's been a creep. He just finally got caught." Jen says, "R. Kelly has way too much time on his hands, sir. Sit down." That's the problem. He is in jail, sitting down. He does have too much time on his hands. He's doing like 20 plus a 30-year sentence. He got 50 years in jail. I'm sure this will not be the last time we hear from him from behind state bars or federal bars at this point. Kayla Eloisa says, "Running late on all my lives today. Hi, everyone. Hello. Welcome into the live stream. Nice to see you tonight. We got some silly things going up. Oh, gosh, Kimmy, we still saying Lizzo lawsuit. We're on R. Kelly. Do-do-do. So hide that. Going away. Oh, yep. There it is. There it is. We got it. Right when I said it. Thank you very much for fixing that. Okay, let's go ahead and jump back into the content of R. Kelly's claims, whatever they may be. Okay, even after this so-called investigation, unlawful access to plaintiff's TrueView records continued. Even after being put on notice of repeated violations of the CFAA by BOP employees, the United States failed to protect plaintiff and breached its duty to protect his private and sensitive information. They didn't fire him. Okay. For example, defendant unknown John and Jane Doe, BOP officer, made an unauthorized access to plaintiff's TrueView records and obtained information about plaintiff's trust account funds in August 2022. What did they find out? Can you please tell us what they found? The unknown defendant BOP officer divulged the information to a journalist for the Washington Post who published the personal information. The publication not only placed plaintiff in a false light, falsely suggesting he was concealing his resources, the monies were actually generous gifts from his loyal fan base. Well, take those generous gifts and give it to the people that you harmed. How about that? How about that, R. Kelly? But resulted in the DOJ confiscating nearly all. That's what he's suing about because they took his money. Oh my god! Why are you putting that much money into your trust accounts? Oh, let me go. They were generous gifts, but resulted in DOJ confiscating nearly all of plaintiff's monies held in his prison trust account, over $25,000. Plaintiff was forced to pay for legal services to litigate the unjustified taking of the money, an issue that is now pending before the Second Circuit of Appeals. How come we didn't hear about that? How come we didn't hear about that case? Plaintiff maintains that the DOJ, because that if it's in the appeals, he is the one that probably appealed it because he probably lost because he's not supposed to have that money. Okay, Plaintiff maintains that the DOJ had no authority to confiscate those funds, which would have not occurred in any event if the information was not leaked to the public by a defendant known as John or Jane Doe. So I don't get it. So the prison let him have that money in the account until the public found out. That's kind of sketch. Sounds like they were actually protecting him, and then they had to do something about it after everybody found out. So I don't know. I don't know if that's a good argument for you. The defendant BOP officer committed the tort of invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton misconduct. The defendant BOP officer, including defendant BOP officer A, has committed violations of Computer Fraud and Abuse Act. Plaintiffs suffered a multitude of loss and damages as a result of the defendant United States of America's negligence and the torts committed by defendants BOP Officer A and other unknown John and Jane Doe BOP officers, including but not limited to legal fees and emotional and psychological distress. Separately, losses in excess of $5,000 accrued as a result of the CFAA violation committed by defendant BOP Officer A. This misconduct resulted in an internal investigation by the BOP and investigation by the DOJ OIG, and both the seizure and examination of the BOP computer hard drive. Okay. This is ridiculous. This is absolutely ridiculous. I'm glad I found the case. Okay, let me take a pause here. Oh, I think Kimmy had that one out. My bad. Let me take a pause here. R. Kelly. R. Kelly. Come on now. Come on now. And then the facts are going to give us more juicy details that I'm ready to get into. Hopefully, it's not too long, but I'm ready to get in the juicier details. This was more like a summary of what has happened. But you're mad because they took your 25K when you owe restitution to people. You owe restitution to people for violating them. Okay? And you're mad that they took your money. Not saying that the officers were right in looking all in your business and selling it to the Washington Post, allegedly, but you owe people money. You don't need no more snacks. You're mad because you can't buy top ramen. No, it's probably not top ramen, but cup of noodles when you owe people money for violating them. Oh gosh, get out of here. Let's go ahead and see what the chat is saying. We got Tanya D says he said the United States. That's me. Oh, that says a whole. Yo, I got it. Mary Jane says always money. It's always the money. The money is what got him. Like, you know what? This is wrong. You know what? This is wrong. Let's see. Kelsey says, okay, let me think of the best way to sum it up and stuff. I don't want to derail Bree's. Oh gosh. You guys are on a whole different conversation. Okay, let me see. Too short. Okay, y'all having a whole conversation. All right. So Kimmy Locker says, if R. Kelly has nothing, he has the audacity. He definitely does. Jen agrees. He does have some audacity to bring this claim. Like, $25,000 and you owe people money, I suggest you pipe down. And he already has an appeal pending over that $25,000. So he just basically was like, you know what? F it, I'm suing the whole United States. The whole United States, and you too, Tasha K. And you too, Tasha K, I'm gonna get you. I can't. I got it, Kimmy. Let me see. Let's get back into it. Let's get into the facts because I know there's going to be some juicy stuff. And he's going to try to downplay his charges. Let's look at it. Plaintiff was arrested in the United States District Court, Northern District of Illinois, on July 11, 2019, in connection with a 13-count indictment for child, you're a bad person. Shortly thereafter, plaintiff was separately indicted for more child issues in the Eastern District of New York in connection with RICO charges brought under the case number. Really? That's what you're going to give us? After his arrest, plaintiff was detained in the Metropolitan Correctional Center in Chicago for nearly 2 years until he was transferred to the Metropolitan Detention Center in Brooklyn to face trial in the Eastern District of New York case in or around June 21st, 2021. During this period of time, plaintiff was a pretrial detainee. While detained in the MCC in and around June 2020, plaintiff's longtime girlfriend, Jane Doe, we know who it is, I don't know why you're saying Jane Doe, began behaving in a hostile and accusatory fashion. So you're bringing your relationship drama into a complaint? Okay, let's go. She began behaving in a hostile and accusatory fashion towards the plaintiff without explanation. Jane Doe was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. What does this have to do with anything? These arguments related to money issues, romantic issues, and other highly personal issues. Oh, so you were accepting money from your loyal fans while your girlfriend was out on the streets needing money? Plaintiff later learned that in and around that time, Jane Doe abruptly began cooperating with the government, which led to her becoming the government's star witness against him and Eastern District of New York prosecution. In and around that time, defendant Kibi, a popular YouTube blogger, began publishing information to her 1.1 million subscribers and other viewers, private information about the plaintiff to which she should have had, which she should not have had access. Excuse me. Oh. Candy. Defendant Kibi did not reveal how she received said confidential information. Just by way of example, on November 7, 2019, defendant Kibi posted a video on YouTube titled "R. Kelly Can't Control His Girlfriends While Behind Bars." That's a pretty good title. That is a pretty good title. Is it still up? Is the video still up? I would like to see it. Kibi told her viewers that the information came from a phone tap somewhere. Kibi disclosed information that appeared to come from plaintiff's prison calls with Jane Doe and his girlfriend J.S. Oh, Jane Doe is someone different than J.S.? Oh, yeah. I guess he had a bunch of girlfriends, huh? Kibi appeared to disclose private and personal information about plaintiff's romantic relationship. Defendant Kibi proceeded to divulge on her YouTube viewers the contents of plaintiff's prison phone calls with his girlfriends and others, email communications about his private life, and legal issues with numerous people. Yeah, you do have a lot of legal issues. Visitor logs and trust account information on numerous other occasions, again without disclosing from where she received the information and how she received the information. Plaintiff was incarcerated and had no ability to watch Kibi's YouTube channel or learn the specific information that was being said by Kibi. Then how did you find out? At one point, plaintiff visited with Jane Doe and was shocked and confused when Jane Doe accused him of making certain statements concerning his personal life that were only shared with plaintiff's lawyer at the time. Jane Doe refused to divulge how she received the information, but claimed that she was privy to plaintiff's conversation with his attorneys. How? It's attorney-client privilege. Plaintiff had no idea how certain private information was making its way into the public domain. In early 2020, the BOP went on a complete lockdown as a result of the pandemic for a year. Attorney visits were conducted entirely by phone call and eventually Zoom visits, and face-to-face visits did not resume until late 2022. Okay, so those calls probably were not supposed to be recorded. It is unclear how many of plaintiff's attorney-client communications were shared with third parties by defendant's BOP officer A, or why those communications were being recorded at all. I agree with him there. They should not be recording his conversations with his attorney. In June 2021, plaintiff was transferred to the MDC in Brooklyn, New York, to stand trial in his RICO prosecution. His federal RICO trial commenced on August 9, 2021. A jury returned a verdict against him on September 27, 2021. Plaintiff's current counsel filed an appearance in Eastern District of New York case in October 2021 for the purpose of handling post-trial motions and the eventual appeal. Her role expanded after plaintiff's original trial lawyers withdrew from the Eastern District New York case by January 2022. Wonder why? Because you suck. Okay. Undersigned counsel filed an appearance in the Northern District case on February 18, 2022, with her legal team began preparing for plaintiff's Northern District trial scheduled to commence in August. After counsel's legal team received information about the unauthorized and illegal taking and selling of plaintiff's private information, counsel sought discovery from the government. I didn't know that this was going on. Like, how did I miss all of this? On June 14, 2022, attorneys for the government produced to plaintiff's counsel an application and affidavit for a search warrant under the case caption "in the matter of search of the HP desktop computer bearing serial number," those numbers. The materials did not include plaintiff's name or any of BOP officer's name. Neither plaintiff nor his counsel had access to the anonymously filed search warrant application and affidavit until it was produced by the government on June 14, 2022. The government refused to provide any additional information despite plaintiff's requests. Interesting. According to the materials in June 2022, a special agent of the Department of Justice of the Inspector General Matt Lukes executed an affidavit in support of a search warrant for a computer located in the Northern District of Illinois in violation of the USC statute, that is, unauthorized access of a computer by obtaining information from the Federal Bureau of Prisons. Agent Lukes averred, and I hope I'm saying his name right, Lukes, averred that the OIG received information from the BOP that unknown BOP officer A was suspected of accessing sensitive law enforcement information maintained by the BOP electronic system and providing that sensitive information to an individual who then released the information on social media platforms. Tasha K was in some mess. Because I feel like this was around the same time the Cardi B stuff was happening too, because that trial was at the beginning of 2021. She was into some mess, some real mess, okay? Specifically, the warden of the MCC in the Chicago reported an allegation of staff misconduct to the BOP Office of Internal Affairs when MCC staff became aware that unknown BOP officers, including defendant BOP Officer A, had stolen plaintiff sensitive information from the BOP's electronic system known as the True View system without authority to do so. The BOP's True View system is an application that contains information on inmates, including inmate emails, inmate telephone calls, inmate visitation lists, and inmate funds. The True View system contains information from various other applications and systems existing on BOP's network infrastructure. The information available on TrueView includes information from the BOP application TruePhone, the inmate telephone system, which houses recording of inmate telephone calls. Agent Luke's investigation showed that unknown BOP Officer A had not only made unauthorized access to plaintiff's TrueView records, but stole information from the records, downloaded information, and then divulged that information to YouTube blogger Defendant Kibi. Defendant Kibi then revealed the stolen and sensitive information to the general public and to specific third parties, including Jane Doe. On information and belief, Defendant Kibi and other unknown individuals bought the information from Defendant Unknown BOP Officer A. That is wild. How did he have time to do all of that while at work? But I mean, I guess people do be like effing around at work and not really working. So that's interesting. Okay, we got a couple more pages, and I hope I didn't lose my spot. Okay, yeah, got it. So let me see what the chat is saying. We only got a couple of chats related to what we're talking about, but that's okay. Let's check it out. Mary Jane says, I feel like I used to buy noodles a lot to afford food, but R. Kelly can have prison food. He's going to have prison food. He's not going to have $25,000 worth of cup of noodle. I used to like cup of noodle, though. Cup of noodle is pretty good. I don't eat it anymore, though. I don't know if it's still good. You know, like sometimes when you think about a food that you used to eat as a child and you're like, man, that was so good. I used to snack. It was so good. And then you eat it as an adult and it's like, this is disgusting. I'm like afraid to eat it because I'm like, I feel like it's going to be like, this is disgusting. Like, why did my parents feed this to me? Tiny D says, I love the channel phone calls from prison, the PCPFP. They have a lot of calls from recent cases. Really? Is R. Kelly on there? Is R. Kelly phone calls on there? Let's check it out. That sounds like a good channel. Jen says, wait, can Tasha K use Anti Slapp here? Public interest? No, because maybe on some of the things, but the phone calls are supposed to be private. So maybe, I don't know. I just told you I don't really understand anti-Slapp. It is a public interest, but it is information that's supposed to be protected. Those recorded phone calls of him just talking to his girlfriend and stuff, those are not protected. It's not his wife, but the one with the attorney, yes. As far as his trust account goes, I don't know how protected that is. I'm not in the prison system, so I don't know. Jen says, oh, that's a great question. Illinois does have anti-Slapp laws, but I'm not familiar with them. Okay, yeah. So they have anti-Slapp. I think some of the things may be able to slide through, but she also lost on that defamation claim with our Cardi B already. So, but she's in Georgia. So would he have to sue her in Georgia? I mean, she's online. So, I don't know. I feel like they would still have to sue her in Georgia because that's where she is. I had to yawn. Sorry, y'all. Yeah, so I don't know where they have to sue her. I don't like the little crossing the lines, the state line thing. It confuses me. I don't sue people out of state in my practice. So I don't know. The information constituted inter alia private conversations between plaintiff and Jane Doe and his girlfriend. I don't agree with that. You know, those phone calls are recorded. All prisoners should know that. The communications related to personal and private. That's how we got all that information on Donna Edelson. Talking about she's about to buy a plane ticket or commit suicide, one or the two. So yeah, those conversations are recorded. The communications related to personal and private relationship matters, financial issues, and even attorney-client matters. Only the conversation between you and your attorney are attorney-client privilege, not you saying, I told my attorney that I did it. That is not protected. Sorry. Although plaintiffs did not know at the time that Jane Doe obtained the information, when plaintiff had the opportunity to learn of the contents of the Agent Lutz affidavit, he deduced that information had been stolen by the unknown BOP officer, sold to defendant Kibi, and then exploited for profit when defendant Kibi divulged it to the public, I guess, and to other third parties, including Jane Doe. Defendant Kibi recently admitted, Tasha K, this is what got you in trouble in a Cardi B trial. Stop admitting to stuff in the open. What's wrong with you? Stop. Defendant Kibi recently admitted on one of the broadcasts that she did obtain the information from defendant BOP Officer A, and not only disseminated the information publicly, but provided additional information to Jane Doe and others, including Jane Doe's family members, for the purpose of interfering with plaintiff's criminal prosecution. She said all of that. I highly doubt. I hope she didn't say all of that. When is this episode? We got to see when this was said. The release of the private information on the internet created a feeding frenzy about plaintiff's personal life. I don't think so. I didn't hear about it, but I guess I'm not that cool. So I guess his relationship with Jane Doe and JS, and resulted in the termination of certain important relationships that plaintiff enjoyed with other individuals. The unauthorized release of the information led to a physical fight between Jane Doe and JS that made national news, the theft of thousands of dollars, and the chaos and discord in the plaintiff's life. Your life was already drama, to tell you the truth, but yeah, that does sound pretty dramatic. Now I gotta figure out who this other girlfriend was, because they are not coming to the top of my head. Furthermore, because information about plaintiff's visiting list and trust fund balances became public news, plaintiff was no longer able to enjoy certain important and supportive relationships with people. With, like, who? Your girlfriend broke up with you, you had another backup girlfriend. Okay. Defendant Kibi released the names of certain individuals who supported plaintiff, publicly shamed those people, calling them enablers, and interfered with those relationships, so they didn't want to support you anymore. Being called out by Tasha K made them not support you. Understandably, plaintiff associates did not wish to be harassed or have their employment put in jeopardy because of the illegal conduct of defendants BOP Officer A and Kibi. Plaintiff suffered significant emotional distress as a result of the release of this information, and further worried about other private information was in the hands of third parties. Both before and even after plaintiff learned about Agent Lutz's affidavit, plaintiff spent sleepless nights distressed and confused how his private conversation had been leaked to the public and who was responsible for it. Importantly, plaintiff suffered emotional distress because he did not feel at liberty to speak freely with his attorney. That is true. I feel bad for him I don't know if I feel bad for him, but he should have attorney-client privilege. Plaintiff learned that his attorney-client communications were not only recorded, but information from those calls were released to Jane Doe and presumably others. That's bad. Plaintiff did not and still does not know the extent to which the private information has been divulged publicly. Agent Lutz's investigation revealed that from the period of July 15, 2019 to January 8, 2020, 60 different BOP officers had accessed plaintiff's TrueView recordings, including defendant unknown BOP Officer A. Indeed, defendant BOP Officer A engaged in unauthorized access to the plaintiff's TrueView records a whopping 153 times. He listened to this man. First of all, R. Kelly, you was on the phone a lot. If these were all different phone calls, running your mouth. But if these are all the same phone calls, then yeah, he was being nosy AF and taking notes. To this day, plaintiff still does not know the extent of his damages, injuries, or loss, as the government has refused to disclose the plaintiff's information about what the investigation revealed and the precise nature of the stolen information. Agent Luke's investigation showed that private and sensitive information from plaintiff TrueView records became part of defendant Kibi's content in her Instagram post on January 12, 2020, and videos on November 7, 2019. Gotta go find these. November 8, 2019, and December 22nd, 2019. The information included private information about plaintiff's literacy. Wait, he can't read? R. Kelly can't read? Oh, I think that came out in his documentary though, right? That he couldn't read. Am I tripping? Am I making something up? I feel like that came out in his Surviving R. Kelly. His medical issues, everyone already knew. If he's talking about the STDs, I think people already knew about that. Private information about his romantic relationships. At no point did defendant Kibi reveal the identity of the person who provided her with the information. Indeed, the identity of the individual who revealed the information to defendant Kibi remains a mystery until today. So basically, the government is not telling him who it is, nor is Tasha K is also not telling them who it is. Agent Luke's investigation further showed that unknown BO officer A stole plaintiff's records from the TrueView system, scanned those records. You stole it and scanned it? What's wrong with him? Scanned those records and then emailed that scan to third parties, including defendant Kibi. How do you know? How do you not know who it is then if he scanned it to Kibi? The content of those materials were published on defendant Kibi's YouTube channel. Okay, I guess that's how you know. It just didn't have the name of who sent it to her. Ooh, discovery into Tasha K's emails. About to be fun. Defendant unknown BOP officer A was not the only BOP officer who engaged in unauthorized access of plaintiff's private records. Indeed, Agent Luke's report that at least 60 BOP officers had made unauthorized access to plaintiff's confidential TrueView records during a 6-month period. The BOP knows the precise identity of those officers, as do the officers who engaged in the unauthorized conduct. So what do you want? You want them to come forward and tell you? No, they're going to make you figure it freaking out. Even after the BOP, talking about keeping secrets, is he not the man that kept secrets for years, violating people? He was convicted of doing so, but I digress. Let's go on. Even after the BOP discovered these rampant violations of the CFAA, they allowed the behavior to continue. The plaintiff learned that in and around August 4, 2022, an unknown BOP officer made an unauthorized access to his TrueView records, obtained information about plaintiff's inmate funds. That unknown to BOP officer leaked information about the balance of the funds in this trust account to a journalist of the Washington Post who published an article with the stolen information provided by the defendant unknown BOP officer. Immediately after the journalist divulged the information, the funds in plaintiff's trust were confiscated by the United States Attorney's Office. Plaintiff was forced to hire counsel to litigate whether the U.S. Attorney's Office had the right to confiscate the funds. That's a typo. The fines. Yeah, these attorneys today are not doing that well. Where no restitution judgment had been entered against plaintiff, and he was not in arrears for paying any court-ordered fees and costs. Oh, I thought he did have restitution against him. He's saying no restitution was actually ordered. So I take it back. Sorry, R. Kelly. I thought you owed people money. You probably do, but you saying that you don't. So here we go. Plaintiff promptly filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. So they took $25,000 from you. And you said, you know what? Just add an extra $925,000 on top of that $25,000. Give me some money. I need some money. By letter dated June 15, 2023, plaintiff's claim was denied. That's why he's appealing it. Denied in writing maybe because you asked for $1 million when they only took $25,000. That might make sense, you know? Denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to plaintiff's counsel. No, we're not giving you your money back. This this complaint comes less than 6 months after plaintiff's claim was denied. Okay, why are you telling us that? Okay, so he's suing them for negligence. The police basically should not have been able to access, or the officers should not have been able to access his files. He's also suing for invasion of privacy. Again, they access his files. Then he goes with conversion. They access the files and then sold it to people for monetary gain. Civil conspiracy. He's saying that the BOP, everybody worked together to basically, spread R. Kelly's information for whatever reason that might be. Intentional infliction of emotional distress. He was emotionally harmed. He felt like the officers did it on purpose. Again, intentional infliction of emotional distress against different defendants, and then a violation of computer abuse for him even accessing and scanning and looking at everything. And then, so let's see here. Wherefore, plaintiff Robert Kelly praised this court entered judgment in his favor and against defendants United States of America, BOP Officer A, BOP Officer Jane and John Doe. I didn't see what they said about Jane, but okay. And Latasha Kebe awarded compensatory damages, costs and attorney's fees against all defendants, and punitive damage against each of the individual defendants in their individual capacities, and for such further additional relief as the court deems appropriate and just. So he wants his money. My boy said, y'all took $25,000 from me. I'm gonna need y'all to run me $1 million. I need $1 million because you took $25,000 from who came up with that? Who advised him of that? I don't know. Let's see here. Oh my gosh. Let's see what the chat is saying on the R. Kelly case. Tanya D says Tasha K's mouth clearly writes checks and that her A can't cash. She talks too much. And like I said, I think this is around the same time that the Cardi B stuff was going on, because the Cardi B lawsuit was either at the beginning of 2021 or 2022. I can't remember, but this was all going on around the same time is what it looks like. Kimmy Locker says to Tiny D, I've never seen that saying used so literally inaccurate. Yeah, it is. Definitely is. Jen says there may be another reason no one wants to be your friend, R. Kelly. There may be other reasons, like you getting convicted and them proving that you actually did these things to children. Yeah, that might be a reason. Mary Jane says, Tiny D, say that to Tom Cruise. Let's see. Hella Swanky says, Tanya D, way too much. I just want her to chill. Having me thinking about being on R. Kelly's side is too far. Way too much. Like, I'm there with you, Hella Swanky, because it's like, okay, I see where he's coming from, but do I feel bad for him? No. But does he likely have a legal remedy? Yes. But still, we don't care because it's R. Kelly. Like, I'm with you, Tasha K. Why are you making us feel bad for R. Kelly out here? We don't, but kind of for the legal of you spreading his business, you T channel. Okay. Tiny D says, LOL, she's so bold in her wrongness, so nothing she says wouldn't surprise me. You are so right. Like, she was like, this private information, let me put it on my YouTube channel as the #1 T channel going around in the Black community. Let me go ahead and do that. And then while I'm at it, I'm going to go ahead and talk about Cardi B too. Like, come on. A celebrity suing you is wild. Like, I definitely understand being a celebrity T channel, but multiple celebrities suing you in like a 3-year span is bad. Okay. Mary Jane says there's a docu, what do you mean? Like how he scanned it? I think Tiny D says, Mary Jane, it was called the documentary. Okay, yeah, it was the Surviving R. Kelly Kelly on Lifetime originally, but it might be on Netflix or any number of places. I watched it on Netflix. Let's see here. Mary Jane says he got to give us all money. The stress he put us through, making us even watch that stupid. Well, he didn't make us watch the documentary, but the fact that the documentary had to be made, yes, he owes us all money. Mary Jane says, Tiny D, thanks. They could have they could make a Lifetime movie out of this lawsuit, out of his life at this point. I don't think I would want to watch that out of his whole life, but about this lawsuit and him getting his money taken, that will be hilarious. Kimmy Locker says they're making a musical out of the Gwyneth Paltrow ski trial too. I saw that this morning. That's so weird. Like, why are they doing that? A musical? And they gonna have that man out there looking crazy like he didn't know what was going. That is out of control. That is completely out of control. Mary Jane says, R. Kelly, give us your cup of noodles. We can sell them. He gonna have to do something strange for a piece of noodle, okay? Because he don't have any money anymore. And now he's filing all these lawsuits using all the money that he did have. So he can't let us borrow. And I wouldn't want to touch his cup of noodle with a 10-foot stick, okay? I wouldn't. Okay, I think we're ready to jump into the case of, what's her name? Kaitlin Armstrong. Kimmy, if you are ready for the PowerPoint, I think we are ready for that case. So I'm going to do our transition while I wait for the PowerPoint to make its way backstage. If you're done with it, that's fine. I'm trying to go through it quick because we're rolling up on our 2-hour mark, and we like to keep the shows at 2 hours. We don't like to go too long because people have things to do. I know we love hanging out here, but people have things to do, and it's the middle of the night for a lot of you, and I appreciate you all for staying and hanging in with me later. I'm finding that I could potentially start doing the streams a little earlier, not a lot, but a little earlier, so we can start quicker. All right, we have 33 likes with 22 people watching live. So if you have not already, please do hit the like button. We are doing awesome on the likes. Let's see if we can hit 50 again this live stream. All right, let's go ahead and let's see. I got a couple more chat. Mary Jane says, Kimmy, OMG, yeah, that is wow with the musical. Yes, of course. Okay, so jumping into Kaitlin Armstrong, she just finished her trial in Kimmy told me earlier, Austin, Texas. She was a cycler, and she basically eliminated a maybe love triangle girl. Basically what happened is Kaitlin Armstrong was dating this professional cycler named Colin. I forgot his last name already. And Colin also briefly dated Mo, and I can't remember her first name. Kaitlin found out about it. They were in the same town. Colin had dinner with Mo, and then a couple of hours later, Kaitlin went to Mo's house, shot her twice in the head, unfortunately, again. Same like Dan Markel, twice in the head, except this one, it was from the front. I think Dan Markel's was from the back. And killed this girl because she thought that she was dating her man. Right? She thought that she was dating her man. Let me go ahead and take these off. And Mo wasn't. She went to dinner with them. At that point, her family's understanding is that they were just friends. But Kaitlin didn't agree. Kaitlin did not agree. And the boyfriend's name is Colin Strickland. The police did look at him. Caitlin's defense was like, why didn't you look at Colin harder? They ruled him out. Yes, he went to dinner with her, but he didn't have a vendetta against her. That was his friend. Why would he, kill her? So Kaitlin, not only did her Jeep was located or spotted near the crime scene very shortly after the shooting. The bike, they were professional cyclists. The bike was worth about Mo's bike was worth about $10,000 to $13,000. That was found thrown in the woods maybe 10 minutes or so away from Mo's house. A lot of people thought that was suspicious because it's such an expensive bike. Why would she be that careless? And she was a professional cyclist, so she's going to take care of what helps her win, right? Kaitlyn had talked to friends and people that she knew saying that she could kill the girl if she wanted to. Not only did she, all of this evidence, the bullets matched the gun that Kaitlyn owns, like all of this stuff, but they said, well, Colin and Kaitlyn lived together, so potentially it could have been Colin using Kaitlyn's gun. But then why was Kaitlyn's car seen near the crime scene? But I mean, I guess Colin could have been driving Kaitlyn's Jeep. It possibly could have been Colin, but people were not going for that. Colin didn't have any animosity towards her, but Kaitlyn did have animosity towards her because she had previously briefly dated Colin. But Kaitlyn and Colin had like an on again, off again relationship. So why not? Not saying she should kill Colin, but why take it out on Mo? Why take it out on Mo? You know? And so not only all of this overwhelming evidence pointing to Kaitlyn as doing the crime, she talked to police directly after the shooting, a couple hours after the shooting, and then she decided that she was going to fly to visit her sister somewhere, and then she took her sister's passport and flew to Costa Rica. The next day after the shooting, she used her sister's identity to fly to Costa Rica. She went and got a nose job to try to change her appearance, and she dyed her hair, and she became a yoga instructor in Costa Rica. They looked for her for 43 freaking days. They had to try to find her 43 days. They finally caught up to her, arrested her. As she's awaiting trial, she tried to escape. She went to a doctor's appointment a few weeks ago and tried to escape. She's caught on camera trying to escape. It looks like a consciousness of guilt, if you ask me. She's running away like Donald Edelson. It's absolutely ridiculous. My husband is downstairs bumping music. His birthday is tomorrow. So yeah, and now he's in here commenting. Y'all see him? Hi, honey. You're late to work again. Yes. So I'm just waiting on Kimmy for the PowerPoint, if it's partially done or whatever it may be, so that we can go through it. I did not have the opportunity to like really keep up with the trial. Kimmy really just told me about it today, and then I watched as much as I could before I came on to live stream for you guys. And so one thing that shocked Kimmy and I was that the jury came back even faster than in the Edelson case. In Edelson, it was 3 hours. In this case, it was 2 hours. They found her guilty. She's going to jail. And I believe they sentenced her today too, but I think I did not watch what they sentenced her to. So let me see if they sentenced her. They were supposed to sentence her today. Kaitlin Armstrong. Found guilty. I don't think they sentenced her yet. Oh no, she faces a potential of life and up to 99 years in prison. I mean, 99 years, is that not life at that point? But there's reasons why they do things like that. So I don't know. It doesn't look like they actually sentenced her today. I thought they were supposed to, but it doesn't look like they did. So let me see if I can go through the chat. It is so sad. I don't know why they do this. Like it's a very pointless thing. Like you already had like you were living with the guy at that point. If he was pissing you off that much, then kick him out of your house and move on. You don't go kill the lady that doesn't even want to date the freaking guy. So messed up. Let's see here. Mary Jane says that's expensive. Yeah, the bike was pretty expensive. She's a professional cyclist. I think she became like one of the best in the area, or maybe nationally, if I remember correctly. Mary Jane says there's bikes like that. Yeah, because those people are riding those bikes for a very long time. Like, I don't know how they do it. I couldn't do it. Alpha, thank you for the hey cutie. Tiny says, I haven't heard anything about this case. Kimmy literally just told me about it this morning, and I was like, oh, that sounds like a good case. And there's also another elimination case that we are going to cover as well. That is, it's so nonsensical. And I'm like, why are people like, there's so many ways to catch people murdering people. And I just don't understand, not that it was acceptable back in the day, but it's like, why are people still doing that? You know you're going to get in trouble. You're most likely going to get caught. Mary Jane says, not sus at all. Yeah, going to Costa Rica and changing your nose and your hair and using your sister's passport so that they can't detect you is wild. Thank you, Alpha, if he's still watching by this. When did this happen? I think Kimmy put in the murder was on May 11th of 2022. So fairly recently, about a year and a half ago. Mary Jane says, there's a Lifetime movie on this one? Wow, I didn't know that. Tiny says, happy birthday to Alpha. Thank you for telling him Alpha's, or happy birthday to Alpha. So wait, Alpha 2. See, Jesse says, the case is really crazy. Did you keep up with it? I wasn't able to keep up with it because I didn't know about it. But then when I looked it up, everyone's, not everyone, but a lot of people were covering it. I'm surprised it didn't pop up on my timeline. Tiny D says, definitely a Lifetime movie, Mary Jane. It is, because the Lifetime movies definitely have a lot of like love affairs and things like that. So let's see here. Mary Jane says, happy birthday to Alpha. Thank you for telling him happy birthday. Everybody saying happy birthday. Okay. I don't think I was going to cover opening statements. How long are the opening statements? Let's see here. Yeah, I don't have time to cover opening statements today. I thought we were just going to go through some PowerPoint cliff notes of it, but maybe not. Fellow Scorpio to Alpha. Kimmy Locker says, I cannot with these tech issues. It's okay. We can probably go ahead and cover it next week then. Alphas with a 199 super sticker. Thank you very much of your little pair jamming and dancing. Thank you very much. Kimmy Locker says, my PC is out to get me at this point. It's okay. It's okay. Oh no, it's okay. We'll probably just cover it next time so that we have more time, and that way I can actually like review the PowerPoint, because and then we'll just do like a overview, and then I can review some more of the cases. Or some more about the cases. Alpha says, thank you everyone for the birthday wishes. I appreciate you. Yes, of course. Mary Jane says, give her 1,000 years. They gave her 99 or up to 99 years life and up to 99 years. Alpha says, look at that smile. Thank you. I didn't know you were still on the live stream at this point. Mary Jane says, no, I meant there should be a Lifetime movie. Oh yeah. I was like, no, this would definitely be a Lifetime movie. It sucks that like people do stuff like this. It's completely ridiculous. Miss Chris Mullen, hello, welcome into the live stream. Another member of the channel saying happy birthday, Mr. Bree. Alpha, I hope you're having a fabulous one. He's down there turning up. Okay, he's down there turning up, probably waiting for me to come on down there, which I will very shortly, because we don't have much more to cover. So basically what we'll do next live stream, I know we had her on the cover for this live stream. We briefly gave a little kind of summary of what's going on, so that way you guys can be excited for it over the weekend, and then we'll go a little bit deeper into it on Tuesday, as long as we get our PowerPoint and our review up. Thank you everyone for joining me for the live stream. Make sure you hit the like button if you haven't already, and I hope everyone has a wonderful, fabulous weekend. We will be celebrating my husband's birthday for the second weekend in a row this weekend. His actual birthday is this weekend, so we're gonna celebrate it again, and we're gonna have a good time. I hope you guys have a good time, and I will see you all on the next